In Western Australia, restraining orders are a crucial tool for protecting individuals from various forms of abuse and violence. Since the introduction of the Family Violence Restraining Order, or FVRO, on the 1st of July 2017, the legal landscape has provided clear guidelines for those seeking protection from family-related violence. Governed by the Restraining Orders Act of 1997, FVROs are specifically designed to safeguard individuals experiencing abuse from family members or those in close personal relationships. The Restraining Orders Act of 1997 outlines three distinct types of restraining orders: Family Violence Restraining Orders, or FVROs, Violence Restraining Orders, or VROs, and Misconduct Restraining Orders, or MROs. FVROs are tailored for individuals in domestic or intimate relationships, including married or de facto partners, ex-partners, and other family connections. To obtain any of these restraining orders, one must go through a formal court process where a magistrate issues the order after a hearing. The applicant needs to demonstrate that an act of family violence or personal violence has occurred and is likely to happen again, or that they have a reasonable fear of such violence occurring. When seeking protection through a family violence restraining order, individuals have the option to request an interim FVRO from the court. An interim FVRO serves as a temporary measure, providing immediate protection while the individual navigates the legal process to obtain a final, more long-term order. One notable aspect of an interim FVRO is its ability to be granted without notifying the other party against whom the order is sought. This discretion allows individuals to swiftly secure protection without alerting the alleged perpetrator, ensuring the safety and confidentiality of the applicant during the legal proceedings. Legal Aid offers a comprehensive guide on their website detailing the process and requirements for obtaining an interim FVRO. What is family violence? According to the Restraining Orders Act 1997, Western Australia, family violence and personal violence are detailed under sections 5A and 6, encompassing a broad spectrum of behaviours. These provisions aim to protect individuals, including children, who have been subjected to or have witnessed family or personal violence. Definition of personal violence. Personal violence refers to acts committed against someone with whom the perpetrator does not share a family relationship. These acts include assault or injury, which involves physical assault or causing injury; kidnapping or deprivation of liberty, which means holding someone against their will; stalking, which is a persistent, unwanted pursuit; threats, which involve threatening to commit any of the aforementioned acts; imagined personal relationships, which are acts that would be considered family violence if a family relationship existed; and, similar to family violence, procuring another person to commit personal violence is regarded as committing the violence. What happens if you breach a VRO? Under the Restraining Orders Act 1997, Western Australia, breaching a restraining order is considered a serious offence. Penalties for breach: Family Violence Restraining Order, or FVRO. Offence: breaching an FVRO. Penalty: a fine of $10,000 or imprisonment for 2 years or both. Violence Restraining Order, or VRO. Offence: breaching a VRO. Penalty: a fine of $10,000 or imprisonment for 2 years or both. Misconduct Restraining Order, or MRO. Offence: breaching an MRO. Penalty: a fine of $1,000. Police orders. Offence: breaching a police order. Penalty: a fine of $10,000 or imprisonment for 2 years or both. Legal proceedings for breaches of restraining orders are conducted as follows. If the alleged offender is a child, well, the case is heard in the Children's Court. For adults, the case is heard in the Magistrates' Court. Aggravating factors. Exposure of a child to family or personal violence during the commission of the offence is considered an aggravating factor, influencing sentencing under Section 7, subsection 1 of the Sentencing Act 1995. However, this does not limit the court's discretion to determine other aggravating factors. Time limits for prosecution. Recidivism and penalties. For repeat offenders, Section 61A outlines the following. Definition of relevant offence. This includes offences under Section 61, subsections 1, 1A or 2A, and specific aggravated offences under the Criminal Code. Repeated offences. If an individual is convicted of a relevant offence and has 2 prior convictions for relevant offences within the past 2 years, a mandatory penalty, typically involving imprisonment or detention, is required unless the court deems it clearly unjust and the individual is not a threat. Court's discretion. Courts can avoid imposing imprisonment if deemed clearly unjust, providing written reasons for this decision. Commentary on recidivism. Cases such as Atherton v Western Australia and Gamble v Western Australia highlight the compulsive and obsessive behaviour often associated with repeated breaches, indicating the significant concern for safety and effectiveness of restraining orders. Despite legislative efforts to impose stricter penalties, courts have historically been lenient, leading to the introduction of Section 61A to ensure mandatory penalties for repeated breaches. Conclusion. The Restraining Orders Act 1997, DWA, provides a comprehensive legal framework for addressing acts of abuse and violence within familial and personal relationships. The Act's definitions of family and personal violence encompass a broad spectrum of behaviours, ensuring extensive protection for victims. The provisions for interim and final Family Violence Restraining Orders, or FVROs, allow for immediate and long-term safeguards against potential harm. The severe penalties for breaching restraining orders, including substantial fines and imprisonment, underscore the seriousness with which these violations are treated. The inclusive and expansive nature of the definitions, as highlighted in legal precedents such as CDO v Western Australia, ensures that multiple forms of conduct and behaviour are captured, thereby offering robust protection for those affected by family and personal violence. This legal framework not only aims to prevent violence, but also to provide a secure and supportive environment for victims seeking redress and protection through the legal system.